Hello, Law Geeks. This is a series of practical oriented questions of Constitution 1. Here, the practical oriented question which you're going to get from the question number 9, a compulsory part to be written, where you will have to write two questions carrying 10 mark each. The question is, there was an accused who was compelled by the police authorities to accept that he have committed an offense under the law. Now the question is whether it is a fundamental rights violation or not. Now, speaking of the factual circumstances of the case, here the accused was forced by the police authority to accept that he have committed a crime. First, you would give the factual circumstances to the case, following which you will write about the issue raised. The issue in the cases is the action of the police is valid. And then this particular question is related to Article 20, Clause 3, wherein it talks about self incrimination. Article 20, Clause 3, self incrimination, it says, no person accused of a crime can be forced to testify against himself. We cannot compel any person to be a witness against himself. This is self incrimination. This right of self incrimination. Here, the police officer asking a person to accept a crime is violative of Article 20, Clause 3. For this kind of questions, first writes facts of the case, then the issue raised, and related to the article, mention the details of that particular article and decision, judgment, and the reasoning for the decision. The reasoning for this decision is no, it is not valid. It's violative of article. It is not valid. The police cannot compel anybody to accept the crime, and it's violative of Article 20, Clause 3. And then we have the second case. The second question is a police authority, a government of Karnataka. It's a government of Karnataka who acquired the land of B, and the B wanted to approach Supreme Court under 32. Now the question is it valid? Here, the facts of the case, the government of Karnataka acquired the land of B. B challenged it under Article 32 of the Indian Constitution. Answer to this question is no. Writ under Article 32 cannot be enforced for the cases pertaining to right to property. Why? Because Article 31 was once a part of Indian Constitution. Now it is removed and it is added in Article 300A of the Indian Constitution. Article 44th, it was through 44th Amendment Act 1978. Right to property was removed and added in the 300A, where it has now become a legal right. Since it is a legal right, this right to property cannot be enforced under Article 32. That is the reasoning for not being enforced under Article 32. That is the second case. And the third case we have here, this case is a very important case. Here, the question is, air hostess was to be removed on three grounds. Once she reaches the age of 35, if she is married within 4 years of her service upon her first pregnancy. Here, what the law says, here this is considered to be violative of Article 14, 15, and 16. It was held in the case of Air India versus Nargis Mirza. This case you can mention for Article 14, 15, and 16. This grounds where it is to be terminated upon reaching 35 on her marriage within 4 years of marriage, and the pregnancy is considered to be violative of 14, 15, and 16. And then we have X, a producer of a film. He just questioned about the U and the A certificate, U universal and A adult certificate. Here, this particular question is related to the case decided in the case of K.A. Abbas versus Union of India. Here, in this case, it said, yes, we do agree to the point. Article 14, equality before the law, equal protection of the law. But there is a provision of reasonable classification. Reasonable classification is allowed if it is involving the interest of the society. Since it is a reasonable classification, the court said the certificates, the division of certificates into U and A is valid. Universal and adult is valid. And then the case we have here is A had come to India in 1935. Again, he went to Iraq in 1945, and then he came back and wanted to register himself in India. Now the question is, whether this registration will be approved. First, you're going to write the facts of the case. The facts of the case: there was an appellant who came to India in 1938 and he went on pilgrimage to Iraq in 1945. Again, he came back to India and registered himself as a foreigner. And several times he used to come and got its stay extended. Now, the court said, though he was original resident, he did not acquire Indian citizenship because he did not have a domicile in India. Since he did not have a domicile in India and he also had no intention of residing in India, considering the fact that he did not have a domicile to reside in India, his citizenship was denied. He did not get the citizenship. And this is all about the case studies, 5 case studies. And if you have any queries and if you want to know more about credence law, you can contact to the number given. All the best for your upcoming exam. Your exam is going to be just 9 hours from now. It's 12 o'clock now. Your exam is going to be held at 9:30. All the best for your exam. See you all with the happy faces. Be well prepared. Give importance to all the fundamental rights. Fundamental rights. If you study properly fundamental rights, that in itself would be sufficient for you to clear the paper. Give importance to Article 12 to 35. All the articles from 12 to 35 and relation between directive principles and the fundamental rights, preamble features, quasi-federal features. All the best for your exam.